And we are live, just waiting for our audience to populate the room. Hello, folks. We're just waiting for the meeting room to populate with all the public that's coming in. So just bear with us for a moment. Okay, we seem to have evened out chairs.
Okay, I will open the meeting then. Welcome everybody to the planning board meeting for September 15th. I'm Rick Kander. I'm the vice chair of the planning board and I'm chairing this meeting tonight. I'll begin by calling the roll for the planning board. Alden Clark.
Here.
Beth Delisle. Not here yet. Ann Gardner is going to be absent. Bob Coop.
Here.
Leah McGavran. Not here yet. Bonnie Sontag is not going to be here. MJ Verde.
Here.
Don Walters.
Here.
And Rick Tainter here. Councillor Shan, do you want to open the public hearing from your side?
So this is
You're
the
muted,
joint
Councilor.
hearing on 9/15 for ordinance 8983. I'll take roll call of the Planning and Development Committee. Councillor Eigenman,
Here.
Councillor Wallace.
Here.
I'll also note that Councillor Connell is also in the attendees in the meeting room.
Thank
This
you.
is
Madam.
Councillor Shan. So we have a quorum for the Planning and Development Committee.
Okay, thank you. So we have two items to begin with that are joint public hearings between the planning board and the Planning and Development Committee. One is an ordinance to allow wind energy conversion facilities in the I-95 right of way by special permit. And the other is to amend the section 7A of the off-street parking regulations to address grandfathering of lawfully existing off-street parking deficiencies for existing structures and uses. After that, the Planning and Development Committee will depart, and we have just two items that are not public hearings: an approval of a covenant and plan endorsement for Levitt Court and the request for minor modification at Evergreen Commons. And here's how I suggest that we conduct the public hearing tonight, both public hearings, but particularly the first one, which has a lot of interest in wind energy conversion facilities. First, I will describe the process and where we are in it, and I will ask Councillor Shan to weigh in from the point of view of the Planning and Development Committee. Then we will ask for a presentation of the proposed ordinance from the sponsor and from the Director of Planning and Development. That will be followed by questions for clarification only, for matters of fact, really, from the councillors and board members. We won't be discussing the merits of the proposed ordinance at that point. We're just trying to clarify any points that aren't clear. Then we will open the public hearing. That will be moderated by the planning director, and we will have 2 minutes of comment per person on that. If we go through the whole roster of people who want to speak, we may be able to come back and get some additional comment from people who would like to speak a second time, but I expect there will be quite a bit of comment tonight on this. Then following the public hearing, we'll have a question and answer and discussion of the merits of the proposal by the city councilors, the Planning and Development Committee, and the members of the planning board. And then we will conclude with a vote from the planning board and a vote from the Planning and Development Committee. And that vote could be to make a recommendation to the city council or to continue the hearing to some future date. So just going back to the top, for those of you who have not been in a process like this before, the way a zoning change happens is it comes out of the city council and gets referred to the planning board and the Committee on Planning and Development for a recommendation. And the planning board has a statutory role in this. Under the state law, we are required to hold a public hearing and to report back to the city council within a certain number of days. Under the city charter, both the planning board and the Planning and Development Committee also have a similar or the same type of role. We have to hear the proposal, hear public comment, and then make our recommendation to the city council. We have no power under the planning board or the Planning and Development Committee to approve or reject the zoning amendment proposal. And I really want to emphasize that we are required to go through this process. We've heard some comments that we shouldn't even be talking about this, but under state law, as long as something is given to us by the council, we have to hear it and make a recommendation, carry it through, and then the council decides whether or not to enact it. So that's the and I should also say that this is a continuation of a public hearing that was held last month, and the two bodies also had a site walk last week, which was not a public hearing, and so we didn't discuss the merits of the proposal then. That was just for us to see the area that the proposal was looking at. So that is the overview of it from the planning board's point of view. And Councillor Shand, would you like to add anything to that?
Not too much. I will say that part of the public process, besides having this public hearing, is also hearing from the public, which is, how everything works. We look forward to hearing the public comment tonight after we've had our initial discussions amongst ourselves with regards to what Andy's going to be showing us, which is going to be the updates we requested after the public walk last week. So with that being said, I would like to hand it back over to Director Port. I think his next plan is to show the updates that we requested.
Thank you, chairs. So just for the record, because we do have a larger audience, my name is Andy Port. I'm the Director of Planning and Development. My office and our staff here assist the various boards of the city, including the Planning Board and the City Council, managing the oversight of the development process, the permitting process that goes through the Planning Board, the ZBA, Conservation Commission, and so forth. We also have other responsibilities. But tonight I'll be providing an overview of the zoning amendment that's been sponsored, trying to give some context to it and make sure that everybody understands mechanically how this amendment would work and what the substance of it is. And as Chair Shand mentioned, a couple of maps that help to illustrate the application of the ordinance and some other contextual information. So first off, I'd like to start by just noting that there is existing zoning for wind turbines in Newburyport. This is a specific section of the zoning ordinance. We have a Roman numeral system for the chapter numbers, but it's wind energy conversion facilities is the technical term used by the ordinance. These facilities are allowed by special permit only. They are not allowed as of right. Currently, it's allowed in the business park, and I will be presenting a plan to show that context for folks in a subsequent slide. It requires currently a grant under this proposal would require the granting of a special permit from the ZBA, not the planning board that's here this evening, providing advisory on the proposed zoning amendment, but another board of the city. To address the reason for that special permit process, as with most special permits, is to address the potential impacts of any proposed project, in this case, an installation of wind turbine, one or more wind turbines. And I should note the Conservation Commission approval is also necessary, not under zoning, but under their own regulations, state and local regulations for work near so-called resource areas or wetlands. There are minimum setback and buffer zones in the zoning ordinance. There are also some setback or buffer zone restrictions in the wetland regulations, which is not the primary focus of our discussion tonight. But again, we have some illustrative maps to try to illustrate, as requested by the planning board and city council members, to try to illustrate the application of this ordinance on the particular property that has been proposed for the zoning map or zoning adjustment. And there are some zoning requirements and wetland regulations, like I said, that go into more fine-grained detail about the process of permitting if someone is applying in the future to the Zoning Board of Appeals. I'm not going to that length of detail tonight. This is just a snapshot of the city zoning map. So this is the distribution of zoning areas in the city. What I'm pointing out here is the existing zoning districts where the wind turbines are allowed. That's in the business park. We have these two sub-districts, but it's essentially our larger business or industry park. We also have the old Cabot property or the UFP property down on Hill Street. That is also in that same district. So that is also allowed under the ordinance. The proposed area is shown in purple here. That's the old I-95 corridor, just for context, where it fits in the city. That is currently not an industrial business owned, but a agricultural conservation zoning district. This is an aerial photograph of the city, again, just showing those locations of the city in the area that's proposed here. This is a little closer here, again, just showing that context. You can see there's the Oleo Woods or Russell Terrace extension neighborhood up towards Story Avenue. The city does have a lease of a cell tower site on the corridor up towards Story Avenue. That's the park and ride that you see across the lot, across the street there. And this slide, I think, is good context for folks because it provides a summary of some of the information that's shown in the subsequent maps, but also areas of interest to folks as far as if a turbine were to be installed, where could it be placed? So these are some of the zoning setbacks required in the current ordinance, as would also apply to this particular area of the city if adopted. There's a clear area that's required where no habitable structures can be, and that radius around the tower has to be equal to the blade height. That's the highest point of the blade. The setback from any residential zoning district, at least 300 feet. Setback from any property line, 150 feet. Maximum blade height above the existing grade is the baseline is 300 feet maximum the ZBA can approve. However, there is a provision in the ordinance, which has been here on the books for some time, allowing the Zoning Board of Appeals at its discretion to allow up to 400 feet based on its review of the impacts, which I'll summarize in a moment, some of the areas that the board would have to look at. There is a requirement also for a setback from residential structures. That's 3 times the proposed hub height. So that one is a little harder to illustrate on a map because it's dependent on the any proposed turbine. There is not, to my knowledge, any specific proposal for a turbine at this time. But this is to give you an idea of what the ordinance calls for. If it's a 300-foot turbine, it would be 900 feet as an offset. So from that, I'm going to move to the one other note before the maps, which is these are some of the criteria that the Zoning Board of Appeals has to look at in reviewing a special permit for a wind turbine. First off, there's a shadow and flicker provision. We know that with another turbine in the city, there were some concerns about that issue. The ordinance, and this is just a quote from the ordinance, requires the Zoning Board of Appeals to look at this particular issue and requires the applicant to provide information, in this case, indicating that it's not going to cause a significant shadowing or flicker impacts, and it indicates that the proponent has the burden of proving that the effect does not have a significant adverse impact on neighboring or adjacent uses. So that applicant has to submit a report that can be peer reviewed by the board with a consultant of its choice at the applicant's expense. But that is a criteria that the board can look at in their review of whether to grant a project and what conditions to place on it. There are also reviews done for noise, lighting, and landscaping. And there is a provision for the board to call for before and after sightline comparisons for, say, 4 or more locations that the board is of concern. So the applicant would have to show an existing photo from that location and superimposing a turbine at the accurate height and scale, what that would look like at that location, whether or not trees would block it, whether or not it's fully visible, and so forth. And there's also a provision for a so-called balloon or crane test, and that's so that the board members in reviewing the proposed turbine can actually go out in the field for themselves and witness the tallest point that might be visible to get an idea of the size and scale on their own. So these are some of the maps that we provided. They are posted on the city website with this proposed amendment and some other related materials. This what you're seeing essentially here, we at the request of Chair Sontag, who isn't here this evening, and some of the other members at the prior meeting and the site walk that we had, there was a request for a breakout of a map that we had previously provided where all the overlays where we attempted to show at once. Because that map was a bit cluttered, we created a series of maps. There are 3 maps. Quite simply, this is obviously the corridor oriented to fit on the page a little better. You can see the park and ride over on the right-hand corner there. Hale Street is on the far left. Obviously, you can see the I-95 corridor. For context for everybody, just as a reminder, the whole corridor is the subject of this change here, and it's what we refer to as the old I-95 corridor right of way. This was transferred to the city by the Commonwealth of Massachusetts when they relocated the highway. There is the reason why we're showing these sub parcels on there in the larger parcel that's outlined in orange or red is because those are sub parcels that were called out specifically by the state that could not be used for any purpose other than essentially open space. They wanted to make sure that drainage would work in that area, and they also wanted to make sure that there weren't, if the state ever needed to use any of that area again for the highway, that would not be a problem, and they reserved some rights in the deed for that purpose. But generically speaking, there's no expectation of anything being done in those sub parcels. We've also attempted to show, to the best of our records, the trail network that's in there. And most particularly on this map, what we're trying to show is the wetland resource areas. To be clear, this is not a wetland survey, so we have not had a wetland scientist go out to verify the location of wetlands. They are extensive in that area. This map shows an estimated boundary of that based on geographic information system mappings. And some algorithms, that are run by computers and periodic updates that are provided by the state. So this is the best estimate of where some of the resource areas are throughout the site. The next map helps to show, and if I just toggle for a moment back and forth between them, you can get an idea that is the buffer zone around some of these resource areas. Again, these are estimated, not definitive. The Conservation Commission is the body responsible for reviewing and approving plans that delineate where resource areas are, and then reviewing and approving any projects within the buffer zone or resource areas themselves. But this map kind of gives an estimate of the extent of, from the prior map, resource area to the buffer zone that would be under the Conservation Commission's jurisdiction to review as a permit or a project. So as you can see, there's an extensive area that's covered on the site that's within that jurisdiction. The next map, and again, this is the third map and the last map. This map is really about the zoning slide I showed a moment ago. So the various provisions in the ordinance that have required setbacks. You'll see on this one, for instance, the darker hatch or black hatching. That's the 150 feet buffer from any parcel line. In this case, the subparcels aren't relevant. Those are referenced in the deed, but they're not the parcel involved here. So there is a 150-foot buffer around there. As you can see, there's a big chunk of that parcel that would not be therefore eligible under the zoning ordinance for the installation of a turbine. There is a 300-foot buffer from residential zones. We've attempted to show that as well. You can see that a little bit faintly. I'm not sure if my cursor is really showing up in this right at the moment, but it's a little bit of a bluish line. And it's just outside, in some cases, of the sort of reddish area or pink area that you're seeing. There is also a 300-foot buffer from residential structures that is shown in the reddish sort of pinkish color. And then the other thing that we've shown, which is not a direct number in the ordinance, but again, because of the setback requirement of 3 times the hub height, there is a 900-foot buffer from residential structures shown as an example of if a 300-foot turbine were placed. In the case of the existing turbine that we have in the business park, I believe that's just under 300 feet. About 290 maybe. So for example, that would be the required setback would narrow down where something could be placed, again, based on the turbine's height as a criteria. So there are some limitations as to where something could go in here. Obviously, a wetlands delineation would have to be done to determine how the resource areas and any buffer zones would impact installation. But with these 3 slides, you can get an idea of how restrictive any installation might be in the future. With that, I'm happy to pass it back to the chairs, and if there's any questions, answer those before any public comment you might be taking.
Andy, I don't know if you saw the note from Councilor Eigenman that Beth Delisle is an attendee at this point. Could you promote her to a panelist?
Yes, thank you for presenting. Sorry, I didn't notice Beth there. Thank you.
Okay. So at this point, we'd like to have any questions for clarification or factual issues from the councilors or the planning board members.
Andy, do you have an overlay of the 3 slides that you just showed, just to show exactly what is left that could be used without having impacts?
We have an overlay map that I can display that shows those. That's the one that some of the members felt was a little bit cluttered for visualization purposes. I can, let me just give me a moment to pull that one up. This map, sorry, just want to make sure I have the right one here. I just want to clarify that this map is not definitive. So at the end of the day.
Understood. You still have to do a delineation if you were to go forward, but just to give folks an idea of the limited space. And then also, you had shown earlier the area that's currently zoned that includes the old Cabot plant. Does that go to the 95? What's the boundary for that current zoning?
I'm not sure if I understand the question correctly. Let me just switch the slide to the ortho photo. This parcel right here is the extent. There's actually 2 parcels there, but these 2 parcels are the extent of that district, if that's your question.
Okay, so there's no intersection between what's being requested and what's currently is owned.
There is an intersection, right? So I guess if I understand your question correctly, there would be an L-shape, connection there essentially between these 2 areas. So the existing industrial or business district that's over that facility there, which also includes this diagonal parcel, that would be one of the areas where it's possible. And then there's the I-95 corridor adjacent to that.
Okay.
Andy, are you still pulling up the other composite map? Here we go.
So not too much available.
Yeah, just one other clarification.
Yeah,
Andy.
exactly.
I do believe you mentioned the various parcels, the 1-9X and so forth, all the ones that you said the state has limitations on. That area is not considered at all, right? It's only the subparcel LS1.
Yeah, that's correct. And that's not because of the zoning in this case, but because of the deed restriction from the Commonwealth. So no structures could be placed there essentially.
Right. Thank you.
And Andy, this is Beth. I had a question about the current ordinance for the wind facilities, but I saw that there's a setback waiver.
That's correct. The board does have the ability, it's an interesting provision, but the Zoning Board of Appeals does have the ability to waive at its discretion dimensional requirements of that section.
Okay, would that be the 150-foot
In this
property
instance,
line?
yeah, in this instance, I would say all of those dimensional requirements, the way that wording is in that section of the ordinance.
So they would have to make the showing.
Essentially, the showing to the satisfaction of the board that any impacts were addressed in the various impacts that you saw on the slide that I presented.
Okay, thank you.
Andy, this is Don Walters. Continuing on a theme of setbacks, your first slide said for resource protection areas, there are minimum setbacks and buffer zones. This determination would come under the Concom to the best of my knowledge. Would you confirm that the Conservation Commission has the ability to either through our city laws or ordinance and or state, to either reduce those minimums or conversely increase them?
The Conservation Commission, and we do have the chair, I believe, of the Conservation Commission here this evening, but the Conservation Commission has its own set of regulations, the local wetlands and the state wetlands regulations. There is a no disturb area that they have under the ordinance, but again, we've shown jurisdiction. There's an extensive amount of this area that would be under their jurisdiction. They can review and condition work with it that's within those jurisdictional areas as it's brought to them for permitting.
So allow me just to perhaps phrase the question slightly differently. The Conservation Commission does not have authority or jurisdiction outside of those areas that you just shown.
That is correct.
Assuming for one moment that the wetland delineation or resource delineation is correct.
That is correct. If you make the presumption that the map is
Right,
accurate, which
right.
of course any project would require a wetland survey by a qualified
Understand.
wetland scientist.
Sure, thank you.
Are there any other questions from planning board members or city councilors at this point for clarification? If not, then we can move to the public comment portion of the public hearing. And as I mentioned at the outset, we're going to have limited to 2 minutes per person. I would note that we have received several emails and letters which are on the website for this project or this proposal. And those will be incorporated into the public record for the public hearing. So you're certainly welcome to repeat what you said in the letter or say something different. So I'm going to ask Beth Delisle to be our timekeeper for this and to let people know when we get to 2 minutes per person.
Chair Tom,
And-
sorry, one quick question set. Councilor Wallace just had her hand up for a second.
Sure.
Councilor Wallace, do you have a question?
Yes, briefly, I was just wondering if we will be hearing from the sponsor before public comment.
He hasn't had his hand up.
Well, let me.
That's
put it
fine.
up.
I was just curious if that was part of the process.
Councilor Cottle?
Yeah, I'm prepared to speak to a number of issues that have emerged during meetings with residents in the area and with some other folks that have provided some input here. If you're willing to hear them.
Certainly.
At what time would you like to hear them?
We can hear them now before public comment.
That would be
Okay.
good.
All right. I'm going to respond in, I hope, a systematic fashion that's useful to the boards about some issues that have come to me or that I thought about previously with respect to the Clean Energy Corridor proposal. Most of them are responses to criticism, some of which was well-founded, and I want to note that. At the outset, there are, in my list here, 25 different items I'd like to comment on, and I hope you'll be patient with me as I walk. The first, I'll just like to frame this discussion in terms of potential benefits to the community. One is the obvious one, and that is that as a community, the idea is to put less carbon into the atmosphere. As a municipality, each of us bears some share of the responsibility for carbon in the atmosphere, which contributes to global climate change. But there's also the possibility of economic benefits for the city if we develop something that throws off some income for the city or some energy based on a contractual arrangement with a potential developer that would be used to pay for the operation of public facilities, schools, city hall, water plant, sewer plant, and that sort of thing. I'm going to go through this list in 3 different categories: environmental, quality of life, roughly speaking planning issues and then economic impacts. And I hope you'll bear with me. And this is pretty much in order in the environmental section first. The order in which people presented concerns to me, and I hope that by addressing some of them up front that it'll make us move a little bit faster as we get into the hearing process itself. The very first thing I heard from someone when I proposed this clean energy corridor was that wind turbines kill birds. If that were the case, then the National Audubon Society would not be supportive of wind turbine development, which they are. Wind turbines are no more dangerous to birds than any other tall structure, telephone poles, steeples, etc. I mean, if birds were dropping from the sky near wind turbines, we'd see foxes and other predators sitting around the base of turbines waiting for lunch to fall from the sky. That's not the case. Second, it damages wildlife in the larger sense. Again, I look for some of the supporters, including, besides Audubon, the Sierra Club, Friends of the Earth, National Wildlife Federation, the National Resources Defense Council, and I'm sure there are many others that I could cite, but I'm not going to. The fact of the matter is that wildlife are adaptable. They respond to disturbances and return. This has been observed out in the Parker River Wildlife Refuge when different disturbances took place. I actually participated in a population dynamics study out there in the 1980s, and it's part of my professional training. It was actually instructive to see how quickly the migration and the occupation of disturbed areas is recovered. The loss of a migration corridor, again, this speaks to the adaptability of wildlife. You know, if we paved everything from soup to nuts, then obviously that would be a different type of impact. But there will be impacts, but I would not judge them to be that significant. The third item, this would require a clear cut of all vegetation in the corridor. That is not proposed, nor would I personally support it. A wind turbine of about 500 megawatts occupies between a third and a half acre, which is similar to the normal home construction site in Newburyport. The continuously and permanently disturbed area would be a concrete pad under any turbine, about 40 feet square. Depending on the design, they might go down with deep footings of different types, and we'd have to be careful about wetlands issues and impacts there. But again, it is not a clear cut that has to take place. However, vegetation would have to be maintained and kept back from the rotor tips. Trees that might intrude over time if they grew in that area would have to be trimmed back. And I don't think there's any way around that. I think that's self-evident. Number 4, the loss of carbon absorbing vegetation. Yep, it's a problem. But again, it's offset by the carbon replacement. I'm sorry, carbon displacement. And according to the National Energy Laboratories in Sandia Labs, the replacement factor is at about 30 to 1. That is, for every turbine you put up, the amount of lost carbon sequestration is offset by about 30 to 1. That is carbon that is not placed into the atmosphere because of the turbine's generation by carbon-based generating facilities. Fifth, fumes from the highway would be increased, particularly in neighborhoods closest to this corridor. Carbon dioxide, carbon monoxide would be increased, is the claim, particularly in winter when vegetation is dormant. And I suppose you could measure that, but I'm not aware of any health impacts that have ever been measured, nor any studies that have made this claim or could support it. Sixth, wetlands. This is a significant constraint, and there's no way around it. It may be manageable with careful placement of turbines and close supervision during the construction process. The best location in my mind is probably about a half-mile up the access road toward Hale Street. But I think some guidance from this planning process would be very helpful in this regard. And I'll return to this issue near the end of my presentation. I'd like to move on to issues related to the quality of life. Visual impacts. Residences closest to the turbines would certainly see them if the angle from their homes is not shielded by the tree line, and that would require some study and certainly would be identified during the planning process and the analysis that would have to be taken. It would be certainly visible, these turbines, during the winter when the vegetation is down, and certainly from Route 95. There's no avoiding that possibility. But I really think, and this is speaking personally, that this is a subjective consideration. I take, for example, the Mark Ritchie turbine. If you come across the bridge from Salisbury, the Gillis Bridge, and the Mark Ritchie turbine is juxtaposed behind the steeples in historic Newburyport, I personally, and I'm speaking just personally now, think that that's a nice juxtaposition between the historic nature of the city and our attempt to participate on a long-term basis without damaging the environment further than we already have. Number 8, and this is a big one, flicker. It's an important issue. We didn't take it into consideration adequately during the permitting process for the Mark Ritchie turbine. But it depends on the orientation of the turbines to the east-west axis of sunlight, and also somewhat during the seasons. This site is northeast to southwest, about 27 to 30 degrees off that axis. This is certainly something that would have to be considered during the planning process. I don't think we should walk around, ignore it, skate around it. I'd like to return to this issue at the end of my presentation as well. Number 9, height. I'm taking as an example a Vetsus 500 kilowatt turbine. These are tall structures. A 60-meter turbine to the blade tip would be converted in terms that we're familiar with, almost 300. That is 296.5 feet tall. They're tall. There's no question about it. Noise. Again, the national laboratories at Berkeley University tell us that sound pressures of about 43 decibels can be detected at 300 meters from the average 500 kilowatt turbine. For comparison purposes, an average refrigerator is about 40 decibels. Access to the Little River Trail. The turbines would be visible at the far end of the trail if that's where they were placed, or anywhere along the trail that they were placed, and there's no avoiding that. But they would not prevent the use of the trail. I would argue that preserving the natural corridor there with some generation of clean energy is a net benefit for the community. But again, that's something that you're going to have to consider, and the city's going to have to look at through the planning process as it evolves. Up to number 14, I'm leaning into planning issues now. There is the question of how electricity by any development would get to the electrical grid. I think the best direction would be at the Hale Street end, trenching the power lines underground. There would be an impact, I suggest, along the access road, but again, that would be subject to your guidance. I don't consider that a huge impediment. Someone has stated that the assembly and construction time would take years. This is false. The average, once a pad has been poured and cured, that is, the foundations are in place, it takes 2 to 4 weeks to assemble and wire up a wind turbine of about 500 kilowatts. If there were 2 or 3, which is potentially possible, it might take a bit longer than that, but as I understand from talking to developers, they can tend to fold those those activities upon one another. Where am I in my list? Number 17, traffic impact. There would be, during the construction and assembly of turbines, some vehicles coming in and out of the site to pour concrete. There would be the towers and the rotors would have to be brought in by vehicles that are approved for travel by the Department of Transportation in over the road. And probably, but not necessarily, a crane would be used to set up the turbines. And that's subject to the type of turbine that's assembled and the methods that they've designed for putting them up. Number 18, traffic distraction. One individual who communicated with me said that traffic would drive off the road on 95. There would be an increase in traffic accidents. I don't know of any evidence that this takes place, but I don't think you can necessarily disregard the fact that these are large, unique structures. I know that if you drive down to Hull or Quincy, where there are turbines near the highways, which I've done a number of times when we, for example, when we looked at the turbines down there in Hull and Quincy, they're distracting, causing accidents. I don't know if there's evidence to support that thought. I'd like to move to the economic impact, which some people have identified as problems from their standpoint. First, the payback. There have been some people that claim that it takes years and maybe you'll never get the money out. Actually, it takes between 5 and 8 years, generally speaking, for turbines to recover the cost of developing them. The shorter term would be for a single, shorter term would be for a larger number. For example, if you're 3 years, it would probably be on the 5-year end. It was just a single turbine, probably on the 8-year end of that time period for them to recover the investment and to start paying benefits to the city and to developers. Number 20, again, economic impact. The wind pressure develops a turbine's output. It has to be measured during the planning process, and I'm sure you know that as Mr. Port has identified in his previous presentation. But the typical coastal environment is between 29 and 40% able to drive a turbine. That's what it's known as its capacity factor. We don't know for sure what this particular site would produce in terms of capacity factor, but that would come out of a study by the potential developers of the site itself. Number 21, why don't we put them offshore? I think it's a great idea, but the city doesn't own offshore rights for any kind of development. Number 22, why not along the Plum Island Turnpike? Along the area where the Plum Island Airport is. The FAA would have something to say about that. Planes need clear airspace. And by the way, that land is in Newbury for the most part, and it's privately owned. It's not available to us. 23, and we're getting closer to the end, so I thank you for your patience. Maintenance. All mechanical systems need to be maintained. A contractual relationship with any proposed developer would have to be developed so that they maintain these turbines in good working order and don't create a major problem or just stand there without providing any of the benefits that they might otherwise provide. I see that I skipped a couple of items. Some people have claimed that turbines throw off ice. Generally speaking, that's not the case in this environment. In other places of the world, that has been a problem. Vetsus and the other large developers of these things have addressed these issues, and they tend not to be problematic. Likewise, there's been some concern about the fall radius around them, and I think that too has not borne out. In the early years of development, that was a problem that was identified in a couple of celebrated cases. The Mass Department of Transportation is not concerned, nor is the US Department of Education. It's an issue for the planning office, I think, to consider. And I think that the proposal, as Mr. Port has laid it out, addresses that issue. Let's see, where am I? I said maintenance, right? Number 24, we're getting near the end. Who's going to profit from this? Contrary to some things that some individuals have stated, not me. All residents of the city will actually benefit from having clean energy and cheaper electricity provided to public purposes based on our arrangement with the developer. Would a developer make money? Yes. They're not in the business of doing this out of charity. Number 25, how long would a lease be? Well, that would be based on the negotiations with the city. If we were to enter into an agreement with the developer, that is, if it were permitted and we went forward, typically a 99-year lease is required for them to get financing. So I'd like to just focus your attention primarily and then answer questions on the 4 final issues of concern that are somewhat troubling to me. 1, damage to wetlands. At the outset of this process, at the outset, I spoke with the planning director in some detail, but not as much as I would have liked, nor as much as he would have liked, about the potential impact on wetlands. Having walked the site, which we all did a week or so ago, I think many of us came back saying that there's more wetlands out there than we might have otherwise identified, with the casual eye. I don't know how we can avoid damaging some wetlands during construction or even perhaps during operation, although I don't think that that's necessarily the case. I don't believe compensatory wetlands creation is a good solution in general. It's expensive, it's possible, but it seems to me that that is a very serious constraint in this site. Number 2 of these 4, flicker. I believe it to be possible, and it would be a showstopper from my own, from my own perspective, if a true analysis showed that flicker was going to land in any residential neighborhood. It's not fair, and it shouldn't happen. We made a mistake with the Mark Ritchie woodworking site because the flicker ended up in the Hill Street neighborhood to be a nuisance to people there. If the planning board wants some analysis, great. And I think that there are predictive models from the National Renewable Energy Laboratory and the Lawrence Livermore Laboratories at Berkeley. I've gone in and plugged in some numbers. Frankly, I'm not sure that the results were conclusive. So we'd have to get a little, sharpen up our pencils and work on that a little bit more. Number 3 of these 4, will we get developers to bid? Do we want to go through this entire process before the planning board and the planning development committee to get 8 votes on the city council and then find that we don't have any bidders? I don't think that is fair to residents who are concerned, who have made a considerable effort to understand what this is about, and not good use of your time or that of the city council. However, I'm not convinced at this point that it's dead. I just think that it's something to consider in the larger scheme of things. If we don't think it's likely to get developers to bid, maybe we shouldn't proceed. In the conversations I've had with 2 different developers, both said that they wouldn't bid on a small project that is of just 1 turbine. 3, maybe, because the lead times and the cost of developing turbines is considerable. And where the money is right now, where the development is taking place, is around larger scale turbine farms where they have dozens of them. And the best example that I keep pointing to is West Texas, where a fabled oil man has been developing wind turbines out in the grazing lands in West Texas where there's lots of wind. But he has the economy of scale working for him. We don't necessarily have that here, so it's something to consider. Finally, property values, and this is a bugaboo. It's a difficult issue to address. Studies have shown that a depression in property values between 9 and 13% can take place if, and this is a big if they're within a quarter mile of a turbine, and if they are visible directly from residential homes, from residences. I have to say that the data here and the methodology has been disputed quite roundly. So I don't know quite what to make of it, but I don't think we can ignore it completely. So the bottom line is, I think that this is a constrained site. It's not an ideal site, which is what I said at the outset. I would like the board to consider these things. I'd be happy to answer your questions, point you towards some additional resources if you'd like, and I look forward to hearing what other people have to say about it. My final comment is this. If not this technology, what technology? If not here, where? And if not now, when? Thank you for your patience.
Thank you, Councilor Connell. We have some time, the way we've set this meeting up. I think we'll put off the question and answers from councilors and planning board members until after we've given the public a chance to comment. And so, Andy, if you could move into the public hearing process at this point. And again, Beth, if you could keep tabs on time and let people know when their 2 minutes is up.
Thank you, chairs. First person we have in the audience is Adam Forrest. If you'd like to just identify yourself and your address for the record.
Oh, yes, can you hear me?
Yes, go right ahead. Thank you.
All right, great, thanks. So yes, my name is Adam Forrest. I live at 9 Richardson Path in Newburyport. So thank you very much, first of all, for the time, and to the City Council and the Planning Department for this opportunity and for hearing us all out. There's a number of things, that we learned tonight and that we've learned over the last recent weeks that clearly shows why this rezoning proposal must end now and makes absolutely no sense and has wasted a colossal amount of time and energy for the residents, for the City Council, the Planning Department, and a number of others. As we looked at with the rezoning overlay maps, there is no or little to no land that is actually applicable for use for 1, never mind 3 turbines. There's also, during the walkthrough, it was clear, and as Councilman Barry just mentioned, there was very clear that folks had no idea what was actually on the little river walking paths and trails, and how much conservation and wetlands were actually there. Because folks who were proposing this had actually never been through there or down and experienced the conservation land. The whole problem that we have here is that there are folks that are proposing rezoning who are unfamiliar with land, regardless of the nature of it. We are all for green energy, and we all believe that there's great land already zoned within Newburyport for this process and for this proposal. So what we need to do is actually change the way that we're going through this process and talk to actually residents first, form committees where people understand and know their backyards and look for the places to build green energy and not go looking in other opportunities where they don't fit. This whole thing could have been avoided if we actually spoke to residents first, understood their backyards, understood what was actually going on there before we wasted 3 months and lots of energy and time for this. So thank you very much, and I oppose this rezoning process.
Thank you, Adam. Next person we have is, it appears to be DM Lane. If you could just identify yourself.
Yes, this is Dan Lane, 2 Richardson Path, Newburyport. Appreciate everyone's time this evening. There are a few things that I have issues with in terms of this proposal. One being the safety of our children, right? I know that, Barry mentioned it take 2 to 4 weeks to get this built. Those are very large trucks. It just takes one kid's death to make this a terrible idea, right? I didn't realize you were a wildlife expert, Barry, but I know that there is plenty of wildlife there. And yes, you would have to cut down all those trees to potentially get ROI within 5 to 8 years. It just doesn't make sense to me. Not to mention all the pollution that would come off of 95, and I would appreciate a study or some sort of analysis done, because saying I've never heard of that or it hasn't been done, that doesn't cut it for me and my family and my children, right? I'm not going to accept that. In terms of developers, I want to know the contacts of the developers that you talk to, because I would also like to talk to them. And hopefully that's public knowledge and you can share that. Economic impact. What's the city's plan to reimburse these people that are affected, right? Losing 14% of your home, Barry, that wouldn't be a good thing. What else? Let's see. At the bottom, at the end of the day, this didn't seem like a clean process. It seemed like this was all in a rush, in a hurry. I noticed that this was submitted the 28th. Barry submitted for retirement on the 1st. He won't even be here to face the repercussions. Please reconsider this. I'm totally opposed to this planning in this rezoning proposal. That's all I have to say for now. But I will say, if this goes any further, this HOA will be hiring an attorney. Thank you.
Thank you. Next person we have is Jason Gauss.
Everyone, could you hear me okay?
Yes, go right ahead.
Great, thank you so much. In echoing Mr. Lane's and Mr. Force's comments, I think it's worth reiterating the lack of space and the constraints around establishing a wind turbine along the proposed area. Additionally, I think the proposal and the process around the proposal actually presents a conflict of interest where we would have to engage people who have a vested interest in the success of the study, whereas we may want to look at possibly engaging an independent counsel to perform the study, both from an environmental perspective and a legal perspective, in order to ensure that we have an unbiased report. And then additionally, I think I see that this is like a singular proposal for green energy. I think none of us are opposed to green energy. One of the questions that I have to the planning board and the city council is, if everybody is on board for green energy, why are there not solar panels on every public building? Because it's a similar process, similar credits, free construction, it goes up, it creates free energy, yet we haven't pursued that. And I'm just concerned that we've got a singular focus on one particular proposal without looking at a host of different alternatives and verifying and validating them on their own merits, and then selecting the path forward that works best for the entire community. Again, along with Mr. Lane and Mr. Forrest, I object to the proposal and formally request that it be rescinded and rejected. Thank you.
Thank you. Next person we have is Mark Meanery.
Yeah, can you hear me?
Yes.
Yeah, this is Mark Menery, 5 Morn Road. Thank you for your time, counselors. And thank you to Barry for giving that 20-minute overview. I think one thing that we can all agree on here is that the main fact is that there are no facts. There are no data points. There's no true science here. We just listened to Barry Connell, who made a very, very major proposal to this city, present for 20 minutes with nothing but subjectivity. There was no facts, there was no math, and there was no true data that was presented to the council or the board or this community. That's the biggest issue that I have with this. We're all for clean energy. We're all trying to be more green. And we all agree that our environment is the most important thing that we can care after. This proposal is not the answer. At the end of Barry's presentation, he said, if not now, when? If not here, where? Councillor Connell, you're the one who made this proposal. We look to you as a city councillor to make and come up with a better proposal for this city than something that was not well thought out and presented with zero data and zero facts. This was a colossal waste of time, and I am heavily opposed to this. Thank you.
I would like to say to all the folks that are going to raise their hands and speak that we would like to keep this not personal. I appreciate that Councillor Connell is here, but if you could keep your comments to a non-personal level, that would be appreciated. Thank you very much.
Thank you, Chair. Next person we have is John Routher.
Hi, this is John Ruth here, 8 Moore Road, Newburyport. Thank you for the time today. Just a few things. One is the biggest issue here I see is the rezoning. It's a conservation land. If it's deemed by the developers, it cannot be used for wind turbines. There's no room to build, which is pretty clear. That it could be used for other commercial properties and other development. Secondly, the state highway regulations 3.10.3 is that a turbine must be 1.5 times the height of the turbine away from the highway, which clearly there's no room for that. It'll also be in the wetlands. Councilman Barry also said that he's not sure if there would be a benefit when he was here meeting with residents, but now he's saying there would be a benefit versus a turbine versus taking down all the trees. And he also said there are better areas to put green energy, but it would take too long. And I just asked the council to do it right. And if it takes a little bit longer, let's find the right spots for green energy. I like what someone else had mentioned with the rooftops of commercial or residential, government buildings. But I appreciate the time and I hope that you all are against this proposal.
Next person we have is Judy Warnick.
Hello?
Yes, thank you.
Okay, I'm sorry it was muted. Can you hear me now?
Yes, go right ahead.
Oh, okay, hi. I live on 3 Russell Terrace, Newburyport, and I just have a few things to say. I really feel that these turbines are going to be way too close to a residential neighborhood. I don't know of any other place that has this setup. Usually they're in wide open spaces or in the water. I know that you had said, well, Newburyport doesn't own the water. Well, nor does anyone else own the water. So how have other people gotten permission to put them in the ocean and other water areas? I really feel that this would destroy our neighborhood. And I feel that we're all really responsible tax-paying citizens, and we really need to be regarded as far as what's going to happen to our property values and to our lives. So I really wish you would consider an alternative, whether it's the industrial park, finding open space somewhere else. But please really think this through, because this really isn't fair. I've spent my whole life saving to live here, and I feel like I might have to leave because of this, and I really don't want to. So thank you very much for your time. I appreciate it.
Thank you.
Thank you. Mark Neville, I see you have your hand raised. Mark, you'll have to unmute on your end.
Sorry about that. Can you hear me now?
Yes.
Okay. So this is Mark Neville. I live at 16 Moran Road in the Oleo Woods neighborhood of Newburyport. To echo what all my neighbors have said already, I oppose this ordinance as well. Also, like a lot of my neighbors said, I'm all for green energy. We all are. However, our ecological responsibility to better the environment is not a reason to hastily push a rezoning process that is going to harm currently protected land. When you ask, if not here, where, Well, one of the main issues I have is I don't think there has been due diligence done on other potential sites to install wind turbines or other methods of green energy. And that's been admitted by the councilman who has proposed this. Secondly, the lack of cost benefit analysis. Again, I heard a lot of opinions, a lot of feelings, or, you know, kind of just personal thoughts, but not a lot of facts around the cost benefit analysis of wiping out current wetlands and protected forest against the energy that these wind turbines would provide. So, you know, I'm not making this personal, but I will quote Barry at the end of his presentation. He said, not an ideal site. And that's exactly right. So before pushing this forward at all, or considering any type of rezoning, we need to look at other locations. Thank you.
Thank you.
Mark Munery, I see there's a couple of hands that are still raised out there. Not sure if those are folks that already spoken. We have a Dan Headland.
Hi, can you hear me?
Yes, thank you.
All right, thank you. My name is Dan Headland. I live at 3 Richardson Path in Newburyport. And like the rest of my neighbors, I completely emphatically object to this entire process. Colossal waste of time, due diligence, and I just think it's extremely absurd that we have people who represent our community would propose something like this and never even step foot in, you know, looked at this with their own eyes. So I just think it's really preposterous. You know, in regards to the statement to not make this personal, I completely object to that too. I think that this is completely personal to everyone in this neighborhood. And quite frankly, everyone that uses all of this conservation land, not to mention the people that pushed to get this land set up as conservation to begin with. So this is completely personal. This is a personal community. We all live here. We love it. We want to stay here. We want to keep it the way it is. And lastly, I am 100% for clean energy and green energy, but just not in our backyard. So there's a million other places that, you know, given the time, you can find another spot to put this. Thank you.
Thank you. Chairs, I see we do have a new hand here. Tara Siddell.
Can you hear me?
Yes, thank you.
Okay, I just had three, first of all, Stixmoran Road, Tara Seidel. 3 quick points to make. One question that was not addressed earlier, but I understand that we wouldn't know what the wind power is in this particular site. And I know we wouldn't know exactly what the dimensions would be of the turbines, nor how many turbines we would have. But I would be curious to know what the equivalent energy would be from these 1 to 3 turbines, based on the fact that we know the Mark Ritchie turbine only produces enough energy to cover 60% of what he uses in his own building. I can't imagine that the return, based on what goes to the developer versus what the city takes, would be sizable. And nor do I have a good understanding of what the distribution of those kind of energy credits or that energy would be. So I'd love some clarification on that. In terms of, if not now, when and where, I understand that offshore isn't an option at the outset because we don't own the land, but I am curious that being sited on the Merrimack River with one of the most powerful currents on the East Coast, why we have not pursued hydropower alternatives using the Newburyport side of the Merrimack. And if we've even looked into that underneath, I know one of my neighbors had mentioned underneath the old railroad bridge. It would seem to me there's some options there that we could look into. And the last comment that I want to make is with regard to Barry's remarks about the Audubon Society. And I take issue with that because I think the Audubon Society is fully in support of renewable energy sources, but their support of wind turbines is very much contingent on proper siting. And I feel like this wetlands proposal to have wind turbines in one of the only forested areas of the city and in conservation land would not meet the Audubon's definition of a properly sited location for wind turbines. That's all. Thank you for your time. Thank you all for taking this into consideration. I think it goes without saying that most of the residents in the abutting areas are very much against this proposal, but certainly in favor of pursuing other alternative energy options for the city of Newburyport. Thank you.
Thank you. Shares, I see no new hands raised at this time. Defer to you.
Okay, thank you, Andy, and thanks to all of the members of the public who have weighed in on this tonight. Now we're at the point where we can move into discussion by councilors and board members, including any questions that you may have for Councilor O'Connell or for Andy Port about the proposal before us.
I have a question, just concerning the, I heard it mentioned about an access road. I was curious where you foresaw the access to the site being made. And are you referring to the existing old roadway, or is there something else that you refer to as the access road? Councilor Connell mentioned previously.
Would you like me to reply, Madam Chair, Mr. Chairman?
That'd be great.
Yeah, the old access road, it's roughly 2 lanes wide, although it's been encroached on the edges a bit, was what I had in mind. It's an existing right of way. I think that there is, well, there may be some overgrowth overhead that would have to be trimmed back to get access to the rear portion. I don't think you can come in from Hale Street. I think that the more likely point of entry would be from Story Avenue's end.
Thank you.
Yeah, thank you. Also, given what we've seen with the various overlays and the required setbacks in the existing ordinance, I was curious, does it appear that there would be room for more than one wind turbine in this whole area? It seems very limited, which I think several people have mentioned.
Yeah. Again, Mr. Chairman, is that directed toward me?
That'd be fine. Yes.
Yeah, I think actually Mr. Port is well prepared to answer that, but I'll start. It depends on the constraints imposed by wetlands that would have to be defined, and constraints imposed by your board. If you thought that it was a possibility and you put additional constraints on the land, which is certainly within your purview, that would limit the possible scale of the development that might take place there. And maybe Mr. Port would like to answer that. I don't know if he wants to chime in.
Well, again, I think to a degree, the maps sort of speak for themselves, whether it's the overlay or the separate maps viewed in sequence. With the existing zoning buffers and what's left over there, you still have to go to the Conservation Commission for permitting outside of that. And some of those areas come closer to the resource areas. So, I think as the maps sort of illustrate, there's limited potential here. At best, possibly one, as I view these maps, but again, we don't have a definitive wetland survey here or resource area survey.
I'd like to follow up on that. So as it was discussed earlier, the setbacks are subject to waivers from the zoning board. If regardless of where this happens, under the general provision for wind energy conversion systems, the 150-foot setback from lot lines, for example, is waivable through the special permit process at the zoning board. And similarly, the buffer areas, and I wouldn't want to prejudge what the Conservation Commission might do, but the buffer areas are areas where I believe the Conservation Commission could allow something to happen. So this map may overstate the restrictions within the corridor, I think. That being said, it seems to me that sort of the area that looks least restricted is kind of the area down in this view of the corridor, down toward the former Cabot building, where there is a stretch of upland that crosses over the property line. There's kind of that area of resource area buffer that heads kind of northeast, or it's actually not northeast, but upper right toward the property line. But there's an area of upland there that would be less restrictive. And then a lot of the concern has been about proximity to residences. So it seems to me that the area that is, of all of this area, the area that has the least restrictions and maybe the least objectionable is the portion of the site closest to Cabot. And Cabot already has an allowance for, because it's in a different zoning district. So this use is already allowed there. Would it make sense to start to address some of the concerns to shrink the corridor and to make it clear that we're not intending to put this close to the Oleo Woods properties? I guess that's kind of a general question for everyone, not necessarily directed toward Councillor Connell or Andy, but something to think about.
Well, this is Andy. I'll just say I don't, again, the policy question of where to allow different uses is ultimately up to the council with advisory opinion from the planning board. To me, there definitely is obviously more concern on the Story Avenue end where the Oleo Woods and Russell Terrace extension is, while the zoning setbacks, and I would frankly be surprised, although I've seen waivers and variances granted over the years, I would be surprised to see the ZBA grant variances from the 300-foot or 400-foot heights, for instance. But that being the case, I would agree that the only reasonable location to locate a turbine in this corridor would be on the southern end, close to the so-called Cabot facility, rather than closer to the residential properties close where they approach Story Ave. Again, with this, there's a fair amount of wetlands in that area. So again, it'd be hard to determine whether or not it would be feasible, even on the Hale Street end, given that we do not have a wetlands delineation and the overlapping there could determine to be restrictive. It's not clear.
And Andy, this is Beth. I just had a question. I noticed, that the area that Rick was referring to was probably the most likely area that could be developed. But I did wonder, as far as the wetlands, the fact that some of the area is previously altered where the roadway was, how would that be treated by the Conservation Commission? I mean, the Conservation Commission would be looking to see if a wind turbine would have greater impacts on the wetlands than the currently existing road, correct?
Sure, that's a good question. And again, I would defer to the Conservation Commission, but the roadway itself, I guess if something were to be done here, I'd assume that the roadway bed itself would be used for access. Whether or not a turbine would be placed where the roadway is versus off to the side, it hadn't occurred to me that, until you just mentioned it now, that, discussion could happen about putting it where the roadway is, but where that path is, certainly a discussion could be had about whether or not the turbine is any worse than the extensive asphalt that's there in those locations. But of course, that goes to discussion about, how the trail network works throughout that area, what sort of public access there is. So again, I think there's a, potential for sort of a cleared area, restriction that might be, of impact only because you'd have to have the public access going around that location if a turbine was not offset from the trail itself. So that again would have to be juggled depending on the wetland survey, depending on what whether it's the city or some party working with the city in the future thought was reasonable to present to the Conservation Commission. But a fair argument can be made that the turbine isn't any worse than the trail itself in terms of the environmental impact. But of course, there's a public access concern that I'm sure would be discussed at that time as well.
Counselor McCauley and Counselor Wallace have their hands up. So Counselor McCauley, I think you were first.
Thank you, Chair. This is smack dab in my ward, and what I take umbrage with is that we're trying to squeeze the balloon here. Because when we look downstream from Story Ave, so there are a number of folks on from Oleo Woods, and we say, oh, okay, it's too dense there. We've got, we have a cell tower, which will have some issues with radio frequencies, with the proposed wind turbines to begin with. But when we push this down towards Cabot, what we've now done is we've opened up this can of worms, especially where the proposed site is from dawn until 10 o'clock. The highway will be covered with flicker. Francis Drive, Goldsmith, Berry Drive will be covered with flicker. In the evening portion where the sun is, we will now introduce flicker into the Doe Run neighborhood as well, which is not listed here. It goes to the point that we would say we need studies, but since I've been here for 30 years, I don't really need a study to tell me where the sun comes up and where it sets, and where a 300-foot tower with a blade on it would generate flicker. I think what we've done here is we've tried to for a certain amount of principle, we're ready to throw away the diversity of this buffer zone that we've been building for 20 years. Animals can adapt, but they don't go on vacation for 6 weeks while we're building this. They have to live there. They have to. We can't book them somewhere and then bring them back going forward. So there will be a disturbance, and there will be impact to the neighborhood. I too have come with some quotes, and I'll summarize them from the chair of the AMC and the Sierra Club. They were posted in the Globe 2 weeks ago as they opposed the Vineyard offshore wind turbines. Their statements said that open space and the development of open space has more of an impact removing carbon than this carbon avoidance conversation that goes along with developing these wind turbines. Our problem with clean energy efficiency is we as a city are not in the energy business, right? And we make deals with developers, and we get bad deals. We get 10% of what's on there. And if we want to be serious about being clean, then we'll take back ownership of all of the solar panels that we have on our schools and et cetera, and we'll get 100% of the energy, and we'll give that directly to our residents. But instead, what we do is the city gets a credit for what they can what the developer can sell. They make more than we do. And I bring that up not to whine about it. I bring that up because we trade our land. We trade the use of our land. We trade our open space so that somebody can come in and make more money than we do. And we have to live with the consequences. What you've got here is you've got one neighborhood that is extremely inflamed because of the way this went down in the process and how this is going to be interjected into their life cycle. This buffer on the highway, if you haven't lived there, is critical. I have one on my side. I live across the highway from these folks. This is a wildlife habitat. There are deer runs, there are coyotes, there are raptors. All we need is the 1 in a million chance that one of these 300-foot turbines kills one of our beloved eagles, and we can have facetiously a dead eagle festival, right? So I think this is the wrong spot for this. It's not the right time for this. And I don't think this technology is the right place for this. And as you look at this from a zoning perspective, I think it's dangerous that we can feel that we can rezone conservation land after this same board built up conservation land by these cluster development neighborhoods and say, oh, by the way, we were kidding, because now we're just rezone conservation land. I think it's a dangerous precedent. I think it's a slippery slope. And I am agitated because I don't think that any of the residents of Ward 5 have anything to gain in this. Thank you.
Thanks, Councilor McCauley. Councilor Wallace, you're next. And then I see Robert Koop has his hand raised.
Thank you, Chair Shand. I just want to say I fully support green energy, and I give a lot of credit to Councilor Connell for his efforts and his knowledge and wanting to bring green energy to the city. However, I cannot support disturbing dedicated open space to do this type of project. Especially, this is a sensitive area with wetlands, wildlife, recreation. The city council had even, before my time, had even rezoned many of the areas to ag and conservation just so they couldn't be developed. And also just listening to the residents, you know, if it's going to impact quality of life of so many people, I just cannot support it. A couple of things I want to point out that are interesting, and Director Port had mentioned, you know, about the deed. I just want to read that piece. So there's a buffer area. The deed is a little bit tricky. It is available publicly online, but because there's so many different subparcels, but that buffer area directly adjacent to the highway, in the deed, it says it shall be expressly maintained as open space and open space only by the city of Newburyport. So that is why we are not looking at that. The other part where the trail is not specifically in the deed, but it has been accepted and grants have been given to the city of Newburyport to enhance that as a trail. So the one thing I want to bring up is the issue of Article 97. And for those of you who are not familiar with Article 97, it is a designation by the state that there are certain lands that must be open space. And if there's a change of use, you need a approval by the state legislature. You need 2/3 approval by your local legislative body, so it'd be the city council here, and you need unanimous approval by the Conservation Commission, whether it's in a wetland area or not, to change the use of Article 97 land. So who's to say it's Article 97 land if it hasn't been specifically deeded as such? Just one interesting, and I'm not an attorney, I'm not claiming to be, but one interesting court case was from 2017 in Westfield, or Smith v. Westfield, where there was a school that was going to be built on a playground and the residents were kind of up in arms, and the court decided that it was Article 97 land and they didn't need an actual deed for it. And it was recognized on the past usage, the city's acceptance, is it in the master plan, et cetera. So I'm not saying it's Article 97 land. I'm saying the state understands the importance of open space, and the encroachment, even if it's for a good use onto open space, is difficult. So if something is to be Article 97, it's just another hurdle to go through. So I just wanted to bring that up, but our open space is sacred, and I just don't like the idea of disturbing it here or anywhere else. I fully support green energy where it is zoned, where it is smart growth being disturb areas that are already disturbed. So I cannot support this. And but again, I thank Councilor Connell. I've learned a lot through this process, and I think we can continue to look at other areas if this doesn't go through. Thank you.
Mr. Coop?
Thank you, Chair. First, I think I would like to thank Councilor Connell for his support of green energy generally. And when we first talked about this a couple of weeks ago, it seemed to me that the I-95 corridor might be an ideal location for a proposal like this. But it's clear that this is a very constrained site. It's clear that there is very limited opportunity for development of wind turbines here. Clear that the development costs might not align with the potential for development of wind turbines. So it's questionable as to whether any developer would approach this site constructively. But I think fundamentally what I'm missing in this discussion is the broader context relative to Newburyport, relative to green energy, what our goals are as a city, how we see this as an economic benefit to the city that we should get behind at appropriate locations. And I think it would also be worthwhile looking at a case study in another location where something like this has been developed, and we could look at the specifics of the economic benefits. Because I would agree with some of the other comments right now that there is no upside for the neighborhoods that abut this site, and the economic benefit to the city is a question mark. It's very speculative at this point. So I think there needs to be a broader discussion about what the city's goals are. I'm new to the board. Maybe all of these discussions have occurred, and maybe I need to get caught up with that. But it seems there needs to be a broader context within which individual sites could be looked at. The benefits of those individual sites could be looked at relative to the broader goals of the city, and we could move forward in a slightly more orderly way. This feels a little piecemeal, the way it's been brought forward, and I just feel like there needs to be a broader discussion. So thank you.
I see Councilor Eigenman has his hand up.
Yes, I mean, I think we're wrapping up our deliberations, and I did miss the first meeting in August, so I've caught up. To give the punchline first, personally, I don't support this amendment. So you've heard from two of us of the three on the committee, but I want to give some details out of respect for everyone who's dialed in. First, I want to recognize how distressed so many residents are by this proposal. I mean, how really emotionally upset they are. And you are being heard loud and clear. We've received many emails at the city council. It's come through in the live testimony. Your anger is tangible. And it is hard. I don't know that, I really don't think that Barry, I'm sorry, Councilor Connell has any ulterior motives. I mean, if that matters, we're not really supposed to get into motives, even if he did, but I just want to say that. I mean, all of us, when we put forward zoning amendments, and God knows I have, people get emotional, but I just want you to know that the buck stops with the city council. We're elected. We do exercise our independent judgment as best we can, but this is a democracy. It's not an authoritarian place. And so public opinion matters a lot, a lot. Second on the law, I mean, just count on your numbers. I mean, this is the kind of zoning that takes 8 out of 11. Not all zoning does anymore. That was changed earlier this year. Maybe it was last year by a special amendment to the state law. But this one needs 8 out of 11, and the bar is pretty high. And just to boil it down, our current wind turbine ordinance says you can only do them in industrial districts. And, the revolution that this proposal would bring about would be to allow them an ag con and then narrow it down further to this particular agricultural conservation area. So that's a high bar. And you heard from Councilor Wallace, we did actually tighten our restrictions in agricultural conservation land fairly recently in the last few years. For example, to require more acreage if you're going to do a house, because we do still have farms in Newburyport. There aren't many, but one up near Mosley State Park that we really want to keep alive. Third, as many speakers have said, both from the community and counselors and planning board members, and greenhouse gas emissions are a real problem, and renewable energy is a worthy issue. And so, that's not, I don't want anyone to think that we're blowing that off. I mean, the criticism, though, that we haven't done everything else that we could do ahead of considering allowing wind turbines in an agricultural conservation district, specifically the old I-95 and, the Little River Trail area, that's valid, so that's a valid point. What else can we do? We have done some things, we can do more. So we have in place an electricity aggregation plan where all, residents we could do an aggregated contract where we could negotiate to buy our energy for all Newburyporters. Any Newburyporter can opt out. But we can decide at the city council on behalf of the community what we want to optimize. Is it price? To date, it's low price, but we could also look at greenhouse gas emissions and say, we want a certain amount of the energy to be wind or solar or tidal, or if you really want to get into a controversy, nuclear, which is low greenhouse gas. We're also considering legislation right now, actually. We hope it comes out this fall. That's going to require all our departments to measure the energy consumption. We do that piecemeal. That word came up tonight. The school department actually already does a lot of that, but not all our departments do. And the whole point of making our departments measure how much energy they're using is because, first of all, if they could reduce it, it saves taxpayer money. And we've been harping on that for a long time, but also it reduces greenhouse gases. And so it's sort of, I think the nice phrase is leading by example, but another one is, don't throw stones in glass houses. We should get our act together. We also could find other ways to generate renewable energy, and solar was raised on rooftops. We've done some of that. We do actually have, some efforts we've made over the last 10 years. Could we do more? Yeah, we could. So that's valid. Look, the basic problem with wind turbines is that many people, not just the neighbors of this particular area, and of course we've heard in spades from this particular area in Councilor McCauley's ward, they simply don't want wind turbines near their homes. And then I'll talk about what near means. And they don't want them in their natural areas either. That's two different things. One is the effect on them in their homes, and the other is it compatible with an open area, an open space? And you just heard from Councilor Wallace as well that, in her opinion, it's not compatible. So that's what this boils down to. In Ward 2, the Mark Ritchie turbine that exists, I don't personally find it visually offensive. Many people do. So forget the noise and the flicker. They just think it's ugly. They don't like looking at it. But I have many residents. That's the Hill Street and Cherry Street and and so on neighborhood who are not just 900 feet away, some of them are over a quarter mile away. And they're really annoyed by that turbine. And that's just a fact. And I learned that in my years serving them. And there isn't much I can do for them now that it's up. Again, I don't want to get into the legal question of whether they're compatible here, but we're considering zoning, and zoning is all about, does it serve the general welfare? And it's a pretty vague standard where we're just trying to do what we think is fair and right to benefit the overall community. And on balance, I don't think the zoning will benefit the overall community. I think it's just not, it doesn't pass that balance test. And I do appreciate the thoroughness of Councillor Connell tonight in going through his 25 points, because he did identify a reality which some of the planning board members came up with, is that even if we didn't have folks objecting to having wind turbines near them or in their natural areas, we're not going to get very many wind turbines out of this zoning if it were to pass. So with that, Madam Chair, I would make a motion that we report the amendment out with a recommendation that the council not approve it.
Do we want to hear from the planning board as far as their vote, or do you want to take a vote of our committee now? Typically, we let the planning board give us.
No, we want to, I want to deliberate together. I'm just making a motion for the purposes. So I would need a second anyway.
I will second that.
Okay. All right, from our committee.
Planning board members, further discussion?
Yeah, Rick, this is Don. I'm willing to make a similar motion for the planning board, and of course entertain discussion, but I'm willing to make that motion as well.
Okay, is there a second?
I'll second. This is Alden.
Okay, discussion among both the planning board and the planning and development committee, if any. Councilor Shan, how do you want to do this? Do you want to have the planning board? It sounds like the planning board is ready to vote, so.
Yep,
You
you
want to
take your vote from there.
Okay. In that case, I will do a roll call vote, and the motion is to essentially recommend against adoption of the ordinance. Alden Clark.
Yes.
And so a yes vote is a vote against, just to be clear.
Correct.
Okay, Beth Lyle,
Yes.
Bob Coop,
Yes.
MJ Verde,
Yes.
Don Walters,
Yes.
and Rick Taylor will also vote yes.
All right, let's do this amongst the Planning and Development Committee. Counselor Wallace,
Yes.
Counselor Eigenmann,
Yes.
Counselor Shand, yes. 3-0, not to approve, not to recommend approval.
Okay,
Counselor Connell, I see that your hand is up.
Yes, it is. And I'm just going to take one moment because I neglected to say something previously, and I appreciate your deliberation. Thank you for your consideration here. I also want to thank the neighbors for their thoughtful and sincere input. I've had other people stop me and say, oh, what a bunch of, no, NIMBYs, no, it's their neighborhood. I don't know that I heard anybody say something, although sometimes they were factually incorrect, but I don't believe that anyone was insincere about what they said, nor should they be labeled as such. And I just want to put that into the record as well. I want to thank them for hosting me personally at a meeting 2 weeks ago, and so many of them who joined us in our site walk about a week ago.
Thank you, Counselor Connell, and I will say the same. Thank you to the neighbors for coming out. This is what democracy looks like. I will also say, just for the record, that we have voted 3-0 not to recommend approval. So at our next council meeting, which is September 27th, that's when we will be voting officially to not approve this. So that will be the recommendation at that time. Okay.
Okay, so we move on to the next public hearing.
All right.
And this is a public hearing to amend existing section 7A off-street parking regulations to address the grandfathering of lawfully existing off-street parking deficiencies for existing structures and uses. And I don't think I need to do the introduction I did before, so I think at this point it'd be appropriate to ask Councillor Eigerman as the sponsor to explain what is going on here.
Yes, if I may, thank you. It's not as dramatic as it looks. It's really an attempt to clarify and restate what at least I believe, and I think the city council as a majority of the city council thought was the existing law. So I want to say in, I think it was 2017, as stated, culminating in the effective date of an amendment to our downtown parking regulations on December 17th of that year, we had debated several things. One of them was to impose a fee if there is a parking shortfall downtown. Until that time, for many years, so long as a business or other land use of any kind was within proximity of a municipal parking lot, then there was no parking required. And that made a lot of sense because we don't really want to tear down buildings downtown to have surface parking lots. That doesn't make any sense. Instead, we have sort of pooled parking in the form of on street, the Green Street lot, and now adding the parking garage. So another reason we did the amendment was we had just approved a parking garage. But when we had debated it on the floor, and I provided this to Acting Chair Rick Tainter the other day. You know, it's all on videotape on YouTube, and there are contemporaneous emails after the fact, was to clarify that existing businesses were, to use the hackneyed phrase, grandfather. And this was very important to the council, which actually did not originally approve this regulation in 2017, this reform, until that was clarified, and then on reconsideration it passed. So to give an example, if there's an existing retailer, I'll pick on State Street, in one of the old 1811 buildings, those are very small spaces, and obviously they don't have any on-site parking. But we have had instances where a retail space is converted to a more intense use, like a restaurant, which is allowed. So the question is, the question was 4 years ago, well, what happens to that business or that building owner? And the answer is that, again, their grandfather, because it was a new ordinance, they don't have to provide parking for, say, the 3 spaces that the retail store require. It's only the incremental increase for which they're obliged either to provide the parking or pay an in lieu fee of $7,500 a space. So say a good example would be the former retailer that became Loretta's on Pleasant Street. They are exempt from this because they already converted before 2017, but they would only owe for the deficiency, and they could carry forward an existing deficiency. We don't want to penalize businesses and land uses that are vested. And so the purpose of this amendment is to clarify that. I did not think it was necessary until discussions with staff, and I wanted to remove all doubt. I don't think this is controversial because, again, it's the way we've all assumed things are being done, but that's the rationale.
Thank you, Councillor Eigerman. I just wanted to add one thing which you conveyed to me, which was that the idea of a deficiency could also have to do with deficient dimensions of a parking space, for
Oh,
example.
yeah, no, that's an excellent point. Thank you for reminding me. Yeah, the issue there is there are a few downtown businesses that are grandfathered that probably don't comply with the letter of the law on the dimensions of their parking spaces. You know, the traditional dimensions are, I think it's 18 feet by 8 feet or something like that, or I don't have it in front of me. I'm thinking, for example, the O'Brien building, which is in between Richdale's and the screening room. You know, that building's been there forever, and it does actually have parking. People may not be aware behind it. There's a sort of isolated court behind it, accessed by alleyways, both from Prince Place and Pleasant Street. I have no idea, you know, whether their parking spaces meet our dimensional requirements, but, you know, say they were to convert that building, and there had been rumors that it would be converted to more intense uses. The idea of the city council at the time in 2017 was not to penalize them for that and require them to bring into compliance, say, sub-size, undersized parking spaces. They would be allowed to, you know, just keep going what they have. And it was only the increment, again, that the amendment applies to. That was the intent.
Great, thank you. Are there any questions from planning board members or councilors about this proposal?
I have a question. I just
Yes.
wanted to confirm the intent where the language talks about, you know, it can be carried forward notwithstanding any extension, erections, or enlargement. And I guess I just wanted to clarify how we should interpret that. If a building was expanded as far as its floor area, would that mean that only the expanded area would be calculated under the current formula and the existing square footage that has the grandfathered provision be ignored? Or are we looking at the entire space once an addition has been made?
No, it's the former. You said it right. That, again, the intent, as discussed on the record in 2017, and here is, notwithstanding an extension, you don't lose the ability to carry forward a lawful deficiency. Taking the example, I'll go back to this hypothetical State Street retailer. Say the space is 800 square feet, and they don't convert it to a more intense use like a restaurant, but they add, I don't know how the hell they would do it. They add 200 square feet. So it goes from 800 square feet to 200 square feet. This, notwithstanding any extension, erection, or enlargement, which is language that I work with the KP Law, our city solicitor, on, is so that it's only the 200 square feet that has to comply. They're grandfathered on the 800.
Okay, thank you.
Rick, I have one question. Councilor Igerman, maybe you can help me understand one point, and this may be somewhere else in the NZO. I understand the enlargement, whatever, the notwithstanding you just mentioned, and I also understand earlier in the language where you say structure or use. Would you just explain to me why we don't need to say something else about a different use and the incremental impact? You talk about the structure and the incremental impact. So I was just kind of curious, because you used the structure or use previously, and yet we seem to be silent on the use.
Well, I guess I'm troubled that it's still ambiguous, but it's the use has to lawfully exist. So in the example I gave, it had to lawfully exist on December 17th, 2017. So if you change the use from retail that existed on that date to restaurant, then it's a different use. It did not lawfully exist on December 17th, 2017. Let's see.
Well, and thank you. I understand that. I guess what I'm trying to understand is the verbiage of the ordinance. You seem to clarify this, and I understand your grandfather 2017, whether it's the structure or the use. And then furthermore down, then you say notwithstanding the enlargement, erection, et cetera. Why isn't there similar language, notwithstanding for some type of a different use or more intensive use? That was my only question.
I think I need to do some more work with KP Law on this, because the notwithstanding any extension, erection, or enlargement is confusing people. The purpose is, I'll have to work with them, because you're only allowed to carry a lawful deficiency forward. That's it. So it's the deficiency that's protected and carried forward. And just because you extend or enlarge or erect more of something, you don't lose the lawful deficiency. But maybe I should add a phrase saying, but parking requirements shall apply to the incremental increase. Is that what's throwing people?
Councilor Eigenman, what I think it'd be simple to say, to add to extension, erection, or enlargement, to say or change of use, because then you capture the retail to restaurant case.
Okay, all right. Well, if the board feels that would clarify it, that makes sense to me.
Does that clarify it for you, Don?
It does, Councilor Shan, thank you.
So
Thank you,
yeah,
Councilor
I'll propose an amendment here on the floor, which I don't think misleads the public on the public notice. It's so we don't have to renotice it. But so after the word enlargement, I would add comma or change of use. That's a motion. That's a motion. Okay, thank you.
Jared, just to be clear, this is at the end of the new language?
Yep.
Can we get rid of the or before enlargement? Just to keep it correct. Scrivener's error.
Hold on, let me just give me a minute. Notwithstanding any extension, erection, or enlargement of this, how about this? Or enlargement of the structure, comma, or change of use.
Okay.
Of the structure, comma, or change of use. Does that make sense, Beth?
Maybe carried forward for the structure or use. Yeah, I guess I'm just, you're referring to at the beginning that for any structure or use that is existing then and located, any lawful deficiency existing. But it may be carried forward for the structure or use.
Well, you know what? I look, why don't we, I think I'll have to run it by KP Law, but it shouldn't say necessarily the structure or use, because it's really the purpose is to have it run with the land.
Right.
It's the property. So actually, the better phrase might be for the lot, not for the structure or use. You're carrying it forward for the lot. It runs with a lot, so you can do other things with a lot. All right, I need to confer with KP Law. I don't want to waste the time of the board. You have another agenda. So are we able, Andy, to hold this?
Yeah, Counselor, I guess I agree, generally speaking, with one of the changes you were discussing a moment ago about just adding in the use. Generally speaking, I would say you've got latitude here, and I don't know if it makes sense, if there's agreement on the essence of this, to if the planning board wanted to take a motion to support it, then the Planning and Development Committee could work in tinkering language before the council takes it up, or if you wanted to continue this hearing to another date on this particular matter.
Well, I think I know where the planning board is coming from, which is that I need to work with the city solicitor to get the language clearer. But I don't think there's any disagreement on the intent, right? So if I could get a recommendation for the board, it would save us all time. I would ask Chair Shan to keep it in our committee, yes. And so that we can work with KP Law.
I agree with you. I would like to make sure that if there's, and I appreciate there are only 3 attendees left, we should at least open it up for public comment so we can say the public hearing is complete.
Very good. Shall we do that? Shall we open the public hearing at this point?
Right. Is there anyone that's here for public comment on this specific topic? If not, then I think we can bring it back in and at least close the public hearing piece.
So I guess I would look from the planning board for a motion to recommend. Can we get the language back up, Andy? Sorry.
Oh, my apologies. Yep, I'll switch back to that.
Thank you. I guess I'd like to get a motion to recommend adoption of this amendment, subject to clarifying language as discussssed tonight.
Yeah, Rick, I'm happy to make that motion, so moved, and with the clarifying language, I would, and I'm fine with that because we discussed perhaps changing from the structure to the light, as Councilor Aggregation said, as well as the concept of use that several of us have raised. So if everyone else on the board's okay with it, I'll make that motion.
Thank you. Is there a second?
I'll second. Oh, yep.
Okay.
I'll
Any
second.
further discussion before we go to a roll call? None. So I'll call the roll call. Alden Clark,
Yes.
Beth Delisle,
Yes.
Bob Coop,
Yes.
MJ Verdi,
Yes.
Don Walters,
Yes.
and Rick Kainer, yes. Great. So is the Planning and Development Committee then going to vote to continue, or?
So I would vote that we close the public hearing. I don't think we need to finish that. And I think we should vote to keep it in committee.
Okay, so the chair, Chair Shan, you've closed. You don't need a vote on that, I don't think, right? You just closed public comment.
Yep.
The public hearing's closed. Yes, I would move to retain this in committee until such time as we consult with the city solicitor.
Is there a second? Awesome. Okay. Let's take a vote. Councilor Eigenman,
Yes.
Councilor Wallace,
Yes.
Councilor Shan, yes. Motion to adjourn.
So moved.
Second.
All right. Thank you all. Have a good rest of your meeting. Appreciate
Thank
all the
you.
support tonight.
Thanks. Okay. The next item on our agenda is a approval of covenant and plan endorsement for Levitt Court.
Attorney Mita, did you want to give an introductory comment for the submission?
Sure. I didn't know if the chair was ready for that.
Oh,
so,
yes, thank you.
Thank you, Mr. I know it's been a long night for you all. This is Lisa Mead, Teller and Costa on behalf of Caswell Development, who is developing, as you know, 21 to 27 Hancock Street. The board, of course, has approved these special permits and subdivision plans, the decision itself, and we're here with the actual final subdivision plan that needs to be endorsed and recorded along with the covenant for the property. I believe that Mr. Port and Mr. Tainer can speak to the fact that the city has reviewed the plans presented, which were approved by the board previously and consistent with the decision. And of note, the one thing that was left off that has now been added on are to show the easement areas around the trees that are going to be located along Hancock Street. And so I'd request that the board authorize the chair to endorse the plans so that they can be recorded, and endorse the covenant so that it too can be recorded to secure the completion of the infrastructure.
Thank you. Are there any questions of Attorney Mead or of Director Port? No questions. The only question that I have, and forgive me for my ignorance here, there is going to be a written easement document to the city at some point. What is the timing for that, and what is the leverage that the city has at this point? Does that have to do with is it a special permit decision as opposed to the subdivision?
I think it's in, I'm not sure which of the decisions it's in.
If I'm not mistaken, it's in the special permit.
Right. And so I don't know exactly when it says that, but I will tell you that because this is going to be a condominium, it will be before the first occupancy permit is issued, because it has to be placed on the property prior to the declaration of the condominium so that everything's subject to it.
Okay.
So that's when we have to do it by, and that's when you'll have it for sure. Plus, we'll be back in here for a release of that first unit from the covenant. So you'll have a check on us for that too.
Great. Okay. Thank you very much. Any further discussion about this request? So this is look for a motion to approve the covenant and plan and endorse the plan.
Yes, please.
Rick, I'll make that motion. It's Beth.
Thank you.
I'll second it. It's MJ.
Thank you. Okay, with no further discussion, let's go through the roll call. Alden Clark.
And I recuse myself as I'm in a butter.
Thank you. Beth Delisle.
Yes.
Bob Coop.
I think, should I abstain since I have no history on this?
I don't think you need to abstain.
Okay, I'll vote yes then.
MJ Verde.
Yes.
Don Walters.
Yes.
And Rick Tainter, yes. So Attorney Mead, or Andy, do I need to pop down to City Hall tomorrow?
Yes, please.
Yeah, if you could, that'd be great.
Okay, I'll try to get there early in the morning.
And if I could, Mr. Tainter, Andy, I believe I sent you the Word version of the covenant because we need to add Rick's name. So I'm going to send it again tonight before I leave so that you have that.
Sure, thanks.
Okay, the next item on the agenda is request for two minor modifications, actually, for Evergreen Commons. And Attorney Mead.
Thank you, Mr. Chair. Lisa Mead on behalf of Evergreen Commons, Mead, Telemacosta, 30 Green Street. And this is interesting because one of them isn't actually a minor modification, but it is because the city would like to make sure that happens. And so we're going to make it a part of the decision. And the other is a request for minor modification, and both are related. And we have spoken to the board about this previously, as we have spoken to the Conservation Commission, and I'll be in the Conservation Commission about this in a couple of weeks as well. So on the screen, you have the overview of the subdivision, and you see the green, let's call it I don't know, it's like a slice of an apple, right? Up at the top there. So that was a part of the land, is a part of the land that is owned by the developers. That was as part of the decision to be conveyed to the City of Newburyport Water Department to help enlarge their the distance around the well. And so that's all that the decisions required. This is parcel A. That's all that the decisions required. And in fact, as Andy knows, for about a year, I've been trying to and have sent multiple copies of the easement, not easement, but the deed over to the city to accept. The Conservation Commission had a concern once the homes went in and that parcel A, which looks a lot like the open space, how it's delineated from the rest of the property. And really what they don't want to have happen is have people get closer to what is now the forested part of the city's property. So there was a request to put a fence along parcel A. And at first the thought was that the fence would go along that like half moon shape. But the owners had a lot of concern about that. And if you actually go out and walk the area, it essentially puts a fence in the middle of this area that has to be mowed as part of, there it is. The fence would essentially go in the middle of that. And so we went out, Andy and I went out, the water department, the developer, Julia, the conservation agent went out and walked the area to look at really where would be the most appropriate place to put the fence. And Julia and Andy and the water department agreed and requested that the fence be put in along the tree line. So you can see where the tree line is there. And that would prevent people, should they be so inclined, to walking back into the water department property, which I would tell you that is not currently fenced anyway and wasn't fenced before. So the developer did agree to do it. Is a significant expense, I will tell you. There's a long distance along that property line, but the developer did agree to do it. And if you could go back to the plan, just the proposed fence plan.
Yeah, apologies. Let me just switch plan.
So as Andy's doing that, so the first minor request for minor modification is to have this fence installed, and we will be doing that. And it's actually already on order, and it would be as shown on this plan. As I said, both Andy and Julia and the water department superintendent were out showing us where they wanted it to go, and when it actually goes to be installed, they will be out there too to make sure you know how it kind of goes around the trees. The idea is not to cut down any of the existing forested area there, but to have a fence put in that location. So that's the first request. The next request, if you could go to the next plan, is you all recall that of course there was proposed to be a connection from the development to the Whittier Bridge bike and walking path, the Garrison Trail. And as you can see in the middle of this plan is the line of demarcation between a federal highway land, Mass DOT land, and the land of the subdivision or the HOA and the open space. And so we were not able to obtain permission. I think we talked about this about a month or so ago to make that connection. And the suggestion was then made that, okay, fine, if you're not going to make the connection, do the engineering and provide an easement to the city and have it reflected in the conservation restriction, which I'll talk to you about in a minute. And so we have done the engineering. It was provided to Andy and other folks in the city well over a month ago for review before we actually submitted it as a minor modification. So this is the design of it. And you can see the easement area as well around it delineated. And so we will be providing an actual easement document similar to what we just talked about for the trees to the city to be able to install if they desire, and if in fact permission is granted from the Federal Highway Division to do the ramp connection, if that were to ever happen. We did have to make an adjustment and include that in the conservation restriction the last time we sent it off for the last round of review from the Commonwealth. They did not have an objection to it at the time, and I had a conversation with them last week. At the end of last week, I did receive back the third round of comments from the Commonwealth on the conservation restriction. And so it looks like we will be able to wrap up the conservation restriction in short order. But in order to do the final as-built plan, we need to have this easement area approved and delineated so that it can be shown on the plan before that is finalized and recorded. So the applicant would request that The minor modification is that the connection need not be made by the applicant, but that in fact the easement be granted in its stead, and this easement plan become a part of the record as well as the Conservation Commission, and that of course the city get this in the appropriate CAD document as it needs to be. Thank you.
Thank you, Attorney Mead. I have one question. I appreciate what you've done here. And I have one question, which is, does the city have a right of access from the edge of that easement area to the nearest road in the development?
So, Andy, could you go back to the other overview plan you had? So there is a connection, the path connections occur off of the road.
Are you referring to, is there another plan you were?
No, this is it. So you see if you come down off of Brown Avenue onto Duffy, at the top of the map here. So there's, as you take the turn, there's actually a path that comes off of Duffy that leads into the open space and around the wetlands and then up. You can't see it on here because the paths aren't yet created on this date.
I understand that. I just wanted to know whether the city had a right of access to get in there to do construction.
It's absolutely the conservation restriction is public access.
Okay, great. Thank you.
Absolutely.
So I appreciate that. Are there any questions from members of the board about this, about either of these?
Rick, this is Don. I have a question on the non-exclusive construction easement. Perhaps this is for Attorney Mead. I'm looking at item number 5, and it talks about no liability shall be sued by the grantor for a maintenance easement. Where does that come in for the use of this non-exclusive? I'm thinking that maybe that was a typo.
I'm not sure what you're reading.
Well, it was in the public documents. The document is non-exclusive construction easement, and it's item number 5, no liability.
So I haven't drafted an easement for this particular easement yet, Mr. Walters. So I'm not sure.
No, this is the one for.
This was included with the letter, Attorney Mead.
Yeah. And I think what it basically says is if the city takes advantage of this easement and goes onto the property, we can't go after the homeowners association if something happens to us.
Right. So this easement, thank you, Mr. Walters. I forgot that I had actually done this work. So this easement hasn't yet been reviewed in full by the city solicitor because you haven't actually accepted it yet. But this is actually taken from the language, the no liability, as well as there's a provision in here that's related to park use and things like that. It's actually taken from a couple of the other easements that have been used both down at the toll development with the walkway along the private property that has been turned over to the city via an easement, as well as some other easements with this project. So it means that, in fact, the development doesn't assume responsibility for anything that you do, the city, in connection with their use of the easement area.
I understand. So I guess I'm a bit confused because the easement, and I don't know whether there's meets and bounds. It talks about a non-exclusive construction easement. So I'm just questioning the contract structure or language. Why do you have under item number 5, no liability? Why do you talk about? It says of this non-exclusive maintenance easement. It seems to me it uses the word thus. This.
Yeah, it should be construction easement.
Okay, thank you. That's all I have.
Fairly in error. Yeah. Yep.
Okay. Actually, that brings up another point of mine. I actually, to try to get ahead of this, drafted some language that I sent over to Andy this afternoon. Do you have that available, Andy, to put up on the screen? Thank you. So I was trying to pull this together to see if we came to an agreement on this, whether we'd be able to move forward quickly. And I think this should be a construction, maintenance, and access easement, because we're gonna have to build the path, we're gonna have to maintain it over time, and we're gonna have to have it for public access. So that kind of fits in with what Don was just asking. But So these are the two, this is some draft language that I'm offering that we could, if the board is comfortable with these changes, we could act on tonight. And so the first one has to do with, in lieu of constructing the trail connection as referenced in the approved documents, the applicant would convey to the city a permanent construction, and I say construction maintenance access agreement, and provide the city with CAD files. And the second part is just to add language to there was a prohibition on any chain link fences. And so I would just add a statement about the 6-foot vinyl covered chain link fence shall be installed along the tree line, et cetera, et cetera, et cetera. And just reference, each of these references the plans that you've provided to us over the past few days with respect to your request. So I don't know if this language is final, but I'm thinking this is maybe pretty close.
Yeah, I don't have a problem with either. It's certainly the intent of everybody, Mr. Tainter, so I don't have a problem with either of those things.
Okay. Any further questions or discussions by the board?
I just had a question. I guess what was the nature of the problem from the state as far as having this done now? And is it of such a serious nature that we think that it might never be granted?
There is and Andy's going to be able to help me with this name better than I. There's a line of demarcation.
Correct.
That the Federal Highway Administration has along their highways. That is not impossible, as noted with the Garrison Trail, but is extremely difficult to get agreement to pass. And so the mayor requested that we move in this direction instead. So is it impossible? No, it's not impossible. Is it extremely difficult? Yes, it's extremely difficult.
And I would add on to that part of the issue is, I think it's difficult for a private property owner to get access to that, across that line of demarcation. But once the project is wrapped up and it becomes a city project, it may become easier.
Correct, I agree with that.
So I think that's why this is a good way to go.
And Rick, in your experience, having an easement is sufficient to have the highway authority more interested in crossing?
As long as it's an easement, the city is actually the owner of the easement at this point. Yeah.
Okay. I did have a question about what the anticipated cost for construction is. Do we have any idea, Lisa?
No, we didn't do an estimate on that. Ms. Delisle, we didn't. No, I don't know the answer to that.
And whatever happens will probably require us getting a grant of some sort. Are there any other questions or comments about this? And if not, I would request a motion to grant the minor modifications as requested, generally in accordance with the language that I've provided.
I'm happy to make that.
Thank you. Is there a second?
Second that, MJ.
Thank you. Okay, with no further discussion, I'll go through the roll. Alden.
Yes.
Beth.
Yes.
Bob.
Yes.
MJ.
Yes.
Don.
Yes.
And Rick, yes. Great. Thank you.
Thank you. Thank you very much. We appreciate your time.
Very good. Okay, we have the next item on our agenda is approval of the minutes of August 18th, 2021. Several of us send in minor corrections and edits. Nothing major.
Yeah, I have one very minor thing. just on page 4, there's a a reference to me and there's an E on the end of my name, which shouldn't be there.
That's
It's
an easy one.
correct. It's correct in most places, but it's just that one spot.
Great.
Thanks.
If there are no further changes, I'd like to have a motion and second to approve the minutes.
I'll make the motion. It's Beth.
Thank you.
Alden, I'll second.
Okay, thank you. Roll call. Alden,
Yes.
Beth,
Yes.
Bob,
Yes.
MJ.
I abstain. I was absent.
Okay, Don
Yes.
and Rick, yes. Okay. Updates from the chair, who's me for the time being, or the planning director. Andy, what do you have for us?
Well, just that we have a couple more zoning amendments that might be coming along. We have one on the, I think it's October 6th, to talk about the zoning change that we're dealing with health and recreation uses, indoor and outdoor. It's was initiated relative to the tennis court facility down on Low Street. And then that can be elaborated on at that hearing. There's also the potential for having a zoning hearing in the coming weeks or months on short-term rental units again, something that we talked about some time ago. In addition to the housekeeping, stuff that we wanted to work on here in this office with the board, there are other things being generated on the council end, and short-term rental units will be coming back as well. So we'll be getting some information out to you about the most recent version that the council is now working with, to our understanding. But the time frame of that is still not entirely clear. It's based on an earlier meeting tonight. The council had still some debate about what kind of terms to set in that. So it's not 100% clear what the time frame will be, but we may have a hearing on that in the coming weeks as well. I'm happy to elaborate. At this late hour, having worked all day and had the meeting, I'm blanking on anything new to throw at you, but I'm more than happy to elaborate anything you have questions about at this hour.
Could you just let us know the status of the mini reform?
Yeah, it was actually signed yesterday, in the meeting, I believe it was actually Monday night. They had the councilors sign, we were present in person, sign. So we got a copy of that. We can distribute that around, of course, a PDF of the signed version. Unfortunately, we're trying to work with the clerk's office to get the vendor Municode to update the website as soon as possible after the amendments have been approved, so that it reflects those changes. Unfortunately, there's been a bit of a lag time there, but it has been signed, finally adopted. So that piece that we all worked on is now approved. We just want to make sure that it's reflected on Municode accurately.
Thank you. Anything else from you, Andy, before I speak?
No, it's not really a planning board matter, but the folks from Sasaki are doing a presentation tomorrow night to illustrate where they are with the Central Waterfront Park project. So if you're interested in following that, that'll be presented tomorrow night.
When is that?
That is at 7 p.m. Or sorry, 7 p.m.
Okay.
We shifted the time from 6:30 to 7 to accommodate another council meeting earlier in the night.
Okay, great. Thank you.
How do we access that?
That is a Zoom meeting. So via the city website calendar, there's a link for the meeting.
Okay, thank you.
Great.
We also, as typical for these meetings, we repost it to a YouTube channel we've created for our various boards. So if for some reason you couldn't attend.
Yeah, I did see one of those. Okay, thank you.
So getting back to zoning and to the first item of tonight's meeting, I think that the issue of zoning for alternative energy and other resiliency type things is something that we're going to be needing to work on as we go forward. Don, I'm wondering whether the Energy Advisory Committee has any interest in doing any movement on wind energy in the city, and also wondering, Andy, whether the Resiliency Committee today briefly mentioned a few things relating to zoning. I don't know whether they will be working on that. I am very interested in the floodplain zoning to accommodate sea level rise, and I've done some of that work in Portsmouth myself, so I would be very interested in working on that. I actually talked to to Gerard Whitten and Steve Lopez at Merrimack Valley Planning Commission over the past few days about if they would be able to help us with analyzing and mapping contours and to look at an extended flood hazard area. So if we felt that was a good way to go, that would be something they could help us with, I'm sure. But any thoughts about resilience-related zoning?
Yeah, I guess a couple of things. I have tried to reach out to the Energy Advisory Committee. Molly, unfortunately, was out this week, or the sustainability coordinator. But to try to see if they would take whatever feedback they had on the turbine proposal, because obviously that's sort of in their warehouse. Unfortunately, it didn't seem like there was sufficient coordination on the proposal that we saw tonight with the AC to just kind of work out some of the feasibility issues or viability from the energy side and their area of expertise. But we definitely expect they have some interest in trying to codify some requirements, not only the municipal facilities component that Councilor Agaman mentioned earlier tonight, saying that municipal facilities existing and proposed should try to be more efficient, obviously net zero to the extent feasible, something I fully support. They have that sort of in motion to a degree, working out the kinks of that in the coming weeks, the language and how it's written, but to see whether or not they have any other changes they're interested in doing. I've heard various ideas, have not heard anything more specific other than the municipal facility elements that are already in the council docket and being worked on. On the resiliency side, and I definitely would expect the Energy Advisory Committee to focus more on both public and private requirements to some extent going forward. But again, it requires some further discussion with them. The Resiliency Committee definitely has had some discussion recently about, excuse me, where they want to focus their efforts in the next year or so. There has been discussion about the land use regulations and how that factors into things like you mentioned, sea level rise and so forth. But as we saw both tonight in the case of wind turbines, which could be proposed anywhere and potentially have issues, and the Plum Island issue that we saw earlier in the year that was withdrawn, the resiliency ones will potentially be difficult to work through, and they're just like other amendments that we've worked on over the years. That will be a difficult one to wrestle with, only because in potentially adopting regulations that restrict development or expansions in hazard zones, that presents some opposition from folks who have either property they own or they're investing in. There's a lot sort of at stake for folks financially. So those will be sensitive, I think, areas to tread into, even though I think they're necessary for the community to have a dialogue about and come to some agreement on. I would expect those changes to be done more of an incremental basis, just because of the sort of a drastic change all at once might be too much for instance, the council to adopt, or for folks to accept. There needs to be more of an understanding, we think, about issues of sea level rise. So we're working with the Resiliency Committee and a vendor to send out and make available a sort of a brochure, if you will, to emphasize the resiliency issues, make sure the general public is better aware of those issues. And one of the things that I thought might be helpful in that respect, and again, before there's any kind of reconsideration by the council of regulatory changes in, for instance, Plum Island, to have a better public understanding of these issues, so that wherever the council and planning board decide to go on this, that there's a better understanding of the hazards that are actually facing the community, which are increasing over time, going forward. So that being the case, and Rick had a great illustration in a presentation he gave a couple weeks back about in showing at the Bullnose in Market Square how the projected sea level rise and how that could even be viewed in a location like that. So we do have some maps that show things. One thing I thought would be helpful to the comment you made a second ago, Rick, was just that working with MVPC, in addition to anything else they might do, Diane in our office and I have spoken about working with MVPC maybe to take the My Map page that we have online and have either in addition to that or a similar page set up where folks could actually look at a dynamic map showing where sea level rise will impact properties in the future, rather than a sort of a static PDF map, which is a little bit less tangible for folks. And then obviously that could be used as a tool in one way or another for us to discuss where there might be appropriate restrictions in the future, whether or not essentially current flood hazard zones should be looked at we should look at incorporating future, silverized maps in our land use regulations for hazard areas, as opposed to just looking at the current FEMA zones, which don't necessarily account for those future conditions. So those are things to discuss, tools that might be available to us to, better educate the public and better explain where these hazard areas are. But the difficult part, I think, will be, finding with that meter where we land as far as regulatory changes and restrictions in hazard zones.
I think that it might be, the process that we have of having something coming as a formal amendment proposal to the city council, and then all of a sudden becoming a public hearing that people get all hot and bothered about is not the most efficient way to do it. And I think if we start through one of the committees, whether it's the resiliency committee or the planning board, to start looking at these things and kind of coming up with concepts and showing concepts and then eventually translating them into ordinances. It may take a little bit longer to get to the point of being an ordinance, but it may be the educational part of it may be more effective.
Agreed. I think, what I had indicated to some of the resiliency community members that I think at least in the coming year, if, depending on how much longer, we really should be focusing on that public education, side of it, and having some of that dialogue, as opposed to thinking that there should be an ordinance that's brought forward necessarily in the early next year. We should be focused on making sure that there's a good dialogue about the coming sea level rise and what those impacts will be, and having some dialogue about where we think that meter should be, or regulatory changes, if any, rather than, as you pointed out, Rick, going right into, and it happens periodically, but whether a council wants to sponsor an amendment and is anxious to get that going into a docket or into committee, we sometimes find out that, there isn't necessarily enough consensus on that matter. So hopefully we can get some more consensus on where any regulatory changes might be before we spend time at one of these hearings or in committees or reviewing a draft document that's several pages long.
Okay.
Yeah, Rick, I'm also, I'm willing at the next Energy Advisory Committee, some of you may know I'm a member of it, and I'm willing to query the Energy Advisory Committee in a succinct manner to see if there are thoughts of placing energy facilities. I can say there's been a lot of work done in solar facilities, and the fact of the matter is, and it's a fact, not an opinion, is that for developers to own these facilities, there's not enough land, it's not economic. And the reason the city's not going to do it is because it is not economic. So the best, when someone said earlier that the IRRs are not great, I don't want to get into finance 101, but I can tell you when we have a net metering, we get a 10 or 15% discount. We're not putting a penny out. Your IRR is infinity. So the Energy Advisory Committee has focused on those items as compared to some of the other items that perhaps are a bit more off in the future. I will say that in my opinion, the Resiliency Committee has gotten a lot more traction than the Energy Advisory Committee. In one sense, it's a bit of a dichotomy in that if we really had net zero now, the impacts of climate change, sea level rise would not be as impact. So we're talking about doing resiliency, but we're not necessarily, as a city, in my opinion, fighting the root mean cause.
Yep. Okay, good.
I'll get off my soapbox, Ray.
Anybody else have any updates that they'd like to share with the board before we adjourn? If not, go to the last vote of the evening and look for a motion to adjourn.
So
I'll make
moved.
the motion. Oh,
I'll second that.
okay.
Okay, roll call. Alden.
Yes.
Yeah.
Yes.
Bob.
Yes.
MJ.
Yes.
Don.
Yes.
And Rick, yes. Thank you all for making this evening as easy as it could be, given the circumstances.
Thanks.
Thanks.
Good night, all.
Good night.
Thank you.
Good night.
Good night.
Good night.